The pen was already in my hand when the title agent's phone rang. She answered with the automatic politeness of someone who takes 40 calls a day, but her expression changed within 3 seconds, not dramatically. Just a subtle tightening around the eyes that told me the call was not routine. She set her pen down. That small motion, pen down, not pen aside, was the first thing that told me something had gone wrong. "Can you give me one moment?" she said. Not to me specifically. Not to the buyer's agent across the table. Just to the room in general. She stepped away from the closing table with her phone pressed to her ear and her back half turned, giving me the courtesy of not seeing her face while she listened. I watched the back of her blazer. I watched her shoulders. I watched the buyer's agent glance at his phone, then at the window, then at nothing in particular, the careful avoidance of someone who senses a problem and doesn't want to be involved in it. My father had been gone for 4 months. 4 months of death certificates, bank notifications, creditor letters, inventory forms, and court filings. 4 months of my brother calling at odd hours to demand explanations I didn't legally owe him. 4 months of him questioning decisions I had full authority to make, suggesting, in that particular careful way, people suggest things when they want to deny, suggesting them later that maybe I wasn't the right person for this, that maybe our father hadn't been thinking clearly, that maybe things should be revisited. I was the executor. Our father had made that choice himself. The will was signed, witnessed, notarized, and filed with the probate court. There was nothing to revisit. The title agent turned back toward the table. Her professional smile had returned, but it was a different smile now, the practiced kind. The kind trained people use when they're about to deliver news they didn't create and don't want to own. "What happened?" I said before she could start. She set her phone face down on the table. "We received a call from an attorney representing your brother. He's filed an emergency motion in probate court this morning. He's claiming undue influence over your father's estate documents and requesting emergency suspension of executor authority pending a capacity evaluation." I kept my hands flat on the table, not because I was calm, because flat hands don't shake. "He filed this morning," I said. "The filing timestamp is 7:14 a.m., she said. I looked at the clock on the wall. 9:02. The closing had been scheduled for 9 o'clock. I had driven 40 minutes to get here. I had organized every document in this folder across 3 weeks of work. The buyer had driven in from out of state. The title had cleared. The payoff statement was locked in. We were supposed to be sitting in this room for an hour and walking out with a completed transaction, and my brother had filed at 7:14 inches the morning before I left my house, before I got in my car, before I merged onto the highway. He had been copied on every court document since probate opened. He had known the exact closing date because I had disclosed it in a required filing 3 weeks ago. He had done the math. He had set his alarm. "We can't proceed while there's an active emergency petition challenging executor authority," the agent said, her voice carrying genuine apology. "The title company's liability." "I understand," I said. I pulled the printout. She slid across the table toward me and read it. My brother's name, his attorney's name, the timestamp. And below that, in the clean, neutral language of legal filings that are designed to sound reasonable, were the words I had been half expecting since the week after the funeral. Petitioner asserts the decedent lacked testamentary capacity at the time of will execution, and that the nominated executor exercised undue influence over the decedent's estate planning decisions. Petitioner requests emergency suspension of executor authority pending independent capacity evaluation. I read it twice. Then I read the case number at the top and put it in my folder. "I need to make a call," I said. The title agent nodded and stepped into the hallway. The buyer's agent found something important to study on his laptop screen. I called the probate court clerk's office. I had the number saved under a label that said, "Court clerk," because 4 months of estate administration will teach you to save every number that is going to matter at the worst possible time. The clerk answered on the 3rd ring. I gave her the filing number and asked if a hearing had been scheduled. Keyboard sounds. A pause. "Yes. Emergency hearing, Judge Calloway's courtroom. 11 a.m. today." 11 a.m. The clock on the title company wall read 9:04. I asked for the opposing counsel contact from the filing, wrote it on the back of a title insurance envelope, and thanked her. Then I called my attorney. My attorney had handled the estate from day one. She was not the kind of person who performed concern. She was the kind of person who read the footnotes on footnotes and cross-referenced statutes she had memorized 3 years ago just to confirm nothing had changed. She returned calls the same day. In the legal world, that is the nearest available thing to a miracle. When I told her what had been filed, and when, she was quiet for exactly 4 seconds. 7:14, she said. "Yes. Closing was at 9. Yes. He's been on every court notification since probate opened. Every single one, I said. Statutory requirement. He knew the date, the time, the address. Okay, a beat. I'll meet you at the courthouse at 10:30. Bring the original will, the capacity documentation, and the signing video, if you have it. I had the signing video. My father's estate attorney had recorded the will signing as standard practice for clients over 70, not because he expected it to be challenged, because he had been doing this long enough to know that careful things get challenged by the people who dislike what the careful thing says. I told the buyer's agent the closing would be delayed but not canceled. I told him I expected to resolve the matter before noon and asked if his client could extend to 2 p.m. He stepped outside, made a call, came back, and told me the buyer would wait reluctantly. 2 p.m., a hard deadline. The shape of the day just got smaller and more exact. I drove to the courthouse with my folder on the passenger seat and both hands on the wheel. The highway was moving well, which felt wrong for the kind of morning it was. No obstruction, no drama on the road, just 40 minutes of ordinary traffic and morning light while I ran the timeline in my head and looked for every angle my brother's attorney might try. What I didn't know yet, what I couldn't know until I walked through security and checked my phone in the courthouse lobby, was that my brother had not filed just once that morning. The notification came through at 9:47. A court system alert flagging a concurrent proceeding related to the estate. I opened it standing next to the lobby directory board and read it carefully. The way you read something you suspect is going to change the temperature of the room. An Emergency Adult Protective Services referral, filed at 8:30 a.m., by my brother, claiming our father had been isolated from family during the final years of his life, claiming I had accompanied him to every legal and medical appointment in a pattern consistent with monitoring and control, claiming our father had expressed a desire to revise his estate documents but had been prevented from doing so. The referral used the phrases financial exploitation and psychological manipulation of a vulnerable adult. My stomach went cold in a way that had nothing to do with the air conditioning. I stood in the courthouse lobby and read it twice. Every sentence was shaped to sound like a son who loved his father and feared for him. Every sentence at its core was a construction. Our father had wanted me at his appointments because his hearing had deteriorated in his final 2 years, and he needed someone to sit beside him and repeat what was said clearly, to take notes, to ask the follow-up questions he sometimes forgot to ask himself. He had told me this explicitly. He had also told me, on an ordinary Tuesday morning, sitting at his kitchen table with both hands wrapped around a mug, that he had decided what he wanted to do with what he had, and that he did not want arguments about it after he was gone. I had not coached him. I had sat in chairs and waited. I had taken notes and driven home and done it again the following week. My brother had visited 4 times in the last 3 years of our father's life. 2 of those visits were Christmas and Thanksgiving. I had been there 4 times a week, sometimes more when the health appointments stacked up. I put my phone in my bag and walked to the elevator. My attorney was in the 3rd floor hallway at 10:28, briefcase open, legal pad in hand, the precise expression she uses when something is difficult but solvable. I showed her the APS referral without saying anything and watched her read it. He filed the petition at 7:14, she said. The APS referral at 8:30. He staggered them on purpose. He wants the judge to see 2 separate agencies responding to 2 separate concerns filed by a grieving son who was worried long before this morning. It's the same claim filed twice in different rooms, I said. Yes, she said. And that's exactly what we'll say. She turned her legal pad toward me. Walk me through the signing video. What's actually on it? 22 minutes. My father at a conference table. The estate attorney reading each provision aloud, pausing after each one, asking my father whether the language reflected his intentions. My father answering in complete sentences, without hesitation, without glancing off camera for guidance because there was no one off camera. Just him, his attorney, and 2 witnesses the firm had provided. My attorney wrote 3 words: capacity, independent, consistent. Visit documentation? She asked. I had mileage reimbursement logs. Submitted to the estate accountant across 26 months because the accountant had advised tracking caretaking mileage for estate tax purposes. It was not designed as a legal defense. It had become one anyway, the way all careful record-keeping eventually becomes useful in ways you never anticipated when you started. 112 visits, I said. She made a note. And his? I pulled the printed text messages. My brother telling me he couldn't make it for Thanksgiving because of a work trip. My brother asking me to handle the prescription pickup because he was out of town. My brother, in his own words, unavailable. She stapled the pages without comment. The way people staple things when the evidence speaks, and they don't want to add noise to it. He's going to try to make this emotional in there, she said. He's going to talk about his father, about love, about how something just doesn't feel right. Let me carry the legal arguments. You stay factual and quiet. The documents do more than you can. I know, I said. Courtroom 3 was smaller than I had imagined. 6 rows of wooden benches, fluorescent lighting that hummed just below the threshold of distraction, and the particular smell of old case files and floor cleaner that every courthouse room shares like a uniform. My brother was already at the petitioner's table when we entered. He had worn a dark suit I had never seen before. His attorney sat beside him with a legal pad dense with handwriting, already performing readiness. My brother looked at me when I came through the door. He had prepared a face for this moment. Grief and reluctance. The expression of a man who hated that it had come to this. I recognized it because I had seen him practice that expression at our father's hospital bedside when there were other people in the room and he needed them to believe something. I did not return it. I sat down, opened my folder, and organized my tabs. Judge Calloway entered at 11 exactly. She was a compact woman with reading glasses on a chain around her neck and the specific quality of patience that develops in people who have presided over enough family disputes to understand that volume and validity are not the same thing. She sat, reviewed the docket, and said without looking up, "Emergency petition in the matter of," and said my father's name. His name in a courtroom. I kept my hand still on the table. My brother's attorney stood before she finished the sentence with the energy of someone who had rehearsed an entrance. Your Honor, my client appears today because of serious and documented concerns about both the mental capacity of the decedent at the time of the will's execution and the conduct of the nominated executor, who we believe— I've read your filing, Judge Calloway said. Sit. He sat. She looked at my attorney. Response? My attorney stood. Your Honor, the petition was filed at 7:14 this morning. The estate's real estate closing was scheduled at 9 a.m. The petitioner has received statutory notification of every proceeding in this estate for 4 months, including the closing date disclosed 3 weeks ago. He filed less than 2 hours before that closing, with allegations that have been available for him to raise since probate opened. The timing is not incidental. My brother's attorney was on his feet immediately. Your Honor, urgency drove the timing. My client's concerns only recently. You've had 6 weeks of representation, Judge Calloway said. Sit down. She turned back to my attorney. Capacity documentation? My attorney slid 3 documents across. The executing attorney's sworn statement on the signing session. The primary care physician's letter from 2 months before signing, confirming cognitive function. And then, just slightly slower than the first 2, placed on the table in a way that allowed the room to register it as separate. A video recording of the will signing, maintained by the executing firm as standard practice for clients over 70. The silence that followed was the specific kind produced by information that changes the shape of a room. Judge Calloway looked at my brother's attorney. Were you aware of a signing video? A short pause. We had not, no, Your Honor. You filed an emergency capacity challenge without first confirming whether a signing record existed. He straightened. Discovery hadn't. This is an emergency hearing, she said, not a trial. You are asking me to suspend an executor's authority this morning based on allegations you filed without verifying the existence of a video recording of the act you're challenging. She picked up the page. How long is the video? 22 minutes, my attorney said. Judge Calloway looked at the courtroom clock. Then at both tables. I am going to watch 12 minutes. The opening provisions, a middle review, and the close. If the decedent demonstrates consistent and independent understanding of his own documents, I will require a substantive counter-argument. My brother leaned toward his attorney with urgent whispered words. His attorney shook his head slightly, the body language of a plan coming apart at a seam. The bailiff brought a laptop. The video loaded, and for 12 minutes, a courtroom watched my father explain, in complete sentences, in his own voice, without looking at anyone for permission or direction, exactly what he wanted done and exactly why. He paused after each clause to confirm the language was right. He added a clarification about the property line on the house that the attorney had to write down. He laughed once, briefly, at something the attorney said, and the laugh was the kind that is difficult to manufacture and impossible to mistake. When the bailiff closed the laptop, Judge Calloway set down her pen and looked at my brother directly. Not his attorney. Him. Sir, she said. Your father spoke in that recording for 22 minutes about the disposition of his estate. Did you discuss his estate wishes with him at any point during the last 3 years of his life? My brother adjusted in his seat. I expressed my concerns to him. He knew how I felt. And after you expressed those concerns, did he change his documents? A pause. No, my brother said. Did he indicate he intended to change them? The pause was longer this time. He said he'd think about it. Judge Calloway's expression stayed level. He considered your position, she said, and maintained his decision. My brother's attorney tried to recover. Your Honor, the concurrent APS referral documents a pattern of filed by your client, she said, referencing the same allegations as this petition. Filing the same claim with two agencies on the same morning does not increase the claim's credibility. It makes the strategy more visible. She looked at my attorney. Care documentation? My attorney slid the mileage log summary across. 112 documented visits over 26 months, cross-referenced against the estate accountant's reimbursement records. Each entry carries a date, a mileage figure, and a corresponding calendar note. And the petitioner's documented visits during the same period? The text messages went across the table. Judge Calloway read them without expression. Her face did something almost imperceptible on the Thanksgiving message, not judgment, just recognition. What time is the closing? She asked, still looking at the pages. Originally, 9 a.m., my attorney said. The buyer has agreed to extend to 2 p.m. If the estate does not close today, the buyer's rate lock expires in 48 hours. The estate incurs ongoing holding costs and risks losing the transaction entirely. Judge Calloway set the pages down and looked at my brother with a kind of directness that does not require a raised voice to carry weight. You filed an emergency capacity petition at 7:14 this morning, less than 2 hours before a closing that has been on the court record for 3 weeks. You filed a concurrent APS referral at 8:30 referencing the same core allegations. The capacity challenge is contradicted by a 22-minute signing video you did not know existed because you did not request it. The isolation claim is contradicted by a 2-year caretaking record and your own documented absences. She paused. Your father had the conversation you asked him to have. He did not change his mind. He documented his intentions with independent counsel, on video, with a physician's clearance letter on file. My brother's mouth opened. His throat moved. For a moment, he looked not like a man running a strategy, but like a man who had finally arrived somewhere he could not leave the way he planned to. She was always there, he said, and his voice broke slightly at the edge. Every appointment, every decision. You don't know what that looks like from the outside. Judge Calloway let the words sit for a moment before she responded. What it looks like from this bench, she said quietly, is a daughter who drove 40 minutes 4 times a week while you sent text messages explaining why you couldn't come. The courtroom did not react. It simply absorbed it. She picked up her pen. The emergency petition is denied. There is no basis for suspension of executor authority. I am noting in today's record that this filing presents characteristics consistent with an improper delay tactic, and I am referring both this petition and the APS referral for review under professional conduct standards. She looked at the attorney beside my brother and said what she said next with the flat precision of someone making sure it landed correctly. I would advise you to review the no contest provisions in the estate documents with your client before any further filings. The attorney's jaw tightened. He wrote something on his pad that he did not say aloud. Judge Calloway looked at me. Executor, your authority is confirmed. Proceed with the closing. She picked up her pen for the final note. Court is adjourned. My brother stood when others were still seated. She manipulated him. His voice was raw now, unpolished, the performance finally gone. You were always in that room and you think no one noticed. He wouldn't have left things this way if she hadn't. Mr. the bailiff was already moving. Judge Calloway did not look up from her notes. Sir, you may raise further allegations through proper filing with appropriate evidence. This proceeding is closed. My brother stood there while the room reorganized around him. His attorney gathered papers with the contained efficiency of someone calculating what this morning was going to cost in billable hours and reputation both. I did not look at my brother the way I used to look at him at the kitchen table when we were still a family that ate dinner together. I looked at him the way I had looked at the filing printout that morning, with complete clarity about what it was. In the hallway, he found me before the deputy positioned between us. You're going to lock me out of everything, he said. I'm going to administer the estate the way the will directs, I said, still walking. The same way I've done everything for 4 months. His hand caught my sleeve. Not hard. Not harmless either. The courthouse deputy was beside us in 2 steps. Sir, back up. She's my sister, my brother said. And she's asking you to step back, the deputy said. I stopped. I turned to face the deputy directly. He filed an APS referral this morning, accusing me of elder abuse and psychological manipulation. I want this contact documented. My brother's hand dropped. His face shifted into something I didn't have a name for. Not quite shame, not quite anger. The expression of a person realizing that the rules of the game they chose apply to them too. The deputy looked at him. Sir. I walked to the clerk's window and requested certified copies of the denial order, the no contest clause notation, and the hearing record. The stamp came down on each page, clean and final. Then I got back in my car and drove to the title company. I walked in at 12:47 p.m. The title agent looked up from her desk with the expression of someone who had been watching the clock every 15 minutes and trying not to. The buyer's agent closed his laptop. I set my folder on the table, sat in the same chair I had been sitting in when the phone rang that morning, and picked up the pen. Ready? The title agent asked. Ready? I said. We signed for 40 minutes. Every page, every initial, every notarized line. The buyer's confirmation came through by phone. The wire transfer cleared at 1:51 p.m. 9 minutes before the hard deadline my brother had tried to make impossible. When the title agent said, "We're clear to close," I did not feel triumphant. I felt something quieter and more permanent, the specific sensation of having carried a weight so long that setting it down feels less like relief than like recalibrating your balance. I sat in my car in the parking lot for a few minutes before starting the engine. The coffee in my cup holder had been cold since morning. I drank the last of it anyway. The weeks that followed were procedural. I secured the estate accounts, notified the brokerage, updated the court record. When I reached the distribution line for my brother's share, it was not nothing. It was not what he had wanted, but it was what our father had decided was fair. I processed it with the same documentation I had used for every other transaction. No editorial, no delay. Just paperwork moving in the direction it was always supposed to move. He had been left enough to matter and less than enough to control anything, and that proportion had not been an accident. Our father had been a precise man. 2 weeks later, a letter arrived through my attorney from my brother's attorney. It was short, carefully worded, and wanted to explore resolution without further proceedings. What it meant in plain language was that someone had read the no contest clause fully, explained the math of it to my brother, and the math was not survivable. Every filing he had made that morning could be characterized as a direct attempt to contest the will and to interfere with the executor's authority, and the clause did not care about his reasons. It cared about his conduct. My attorney responded with 3 requirements: a written acknowledgement that the emergency petition had been filed without evidentiary basis, a written agreement to correct the APS record and have the referral formally marked unsubstantiated, and a stipulation that my executor authority would not be challenged again without independent verified evidence. He signed all 3. The APS referral was closed as unsubstantiated 6 weeks after the hearing. I requested the closure letter in writing and filed it with the estate record because written is the only version of any history that holds when it needs to. Probate closed the following month. The discharge order was filed. I drove to the courthouse one last time to pick up the certified copy and walked out into ordinary afternoon sunlight that felt slightly unreal after everything that had been done inside those walls. My father had made his decisions 3 years earlier, in a room I wasn't in, on a video I hadn't seen until a courtroom needed it, in his own words with no one guiding them. He had listened to my brother's concerns, and he had kept his mind. He had known, the way careful people who have lived a long time know things, that there is a difference between someone who shows up every Tuesday when the drive is long and the task is unglamorous, and someone who appears at important moments expecting the same weight of credit. He had not been able to say that in the will, not exactly, not in language that would survive a legal challenge, but he had said what he could in the only language that holds: signatures, witnesses, a recorded statement, and a clause that made the cost of bad faith clear before anyone tried it. My brother learned something that morning that I already knew from 4 months of estate work. Systems don't forget. They don't forgive. They timestamp and file and archive, and eventually, they show you exactly what you did and when you did it. The moment I stopped responding to him like a sister who owed him patience and started responding like a record keeper who owed him procedure, the chaos ran out of room to breathe. If someone in your family had tried to weaponize a court filing to block an estate closing on the morning it was scheduled, would you press charges? Settle quietly? Or do what I did and let the timestamps carry the weight? Tell me in the comments. Like and subscribe, and I'll see you in the next one.